to discuss 4 actual cases of real, live people. Let's go back and review. Courts of inferior jurisdiction, where we have to start out. How do they get jurisdiction? That's right, from pleadings sufficient to invoke their power to act. And where do they get these pleadings? They get them from the people that are litigating when they do it right. We have a common sense, which means that before we know what any statute, rule, constitution means, we're going to have to look at what the Supreme Courts have ruled and determined that it means, and we find that where? In the state annotated. Jurisdiction is a 4-legged table. You've got to have 2 people, you've got to have the subject matter, and you've got to have the competent witness. If any of those elements is missing, the table falls down, it's void, and is subject to being vacated. Now we're going to start looking at some actual cases. The first case that I'm going to tell you about is Tim. Now, before I tell you about Tim, there is a pass out in your materials that I hope is handy. And this is a letter to a collection agency. Anybody ever heard from a collection agency? Okay? There is a letter to a collection agency that I have used by count 9 times. There has yet to be reported to me a single response. This letter will empower you to learn. Do what? Yeah, I think it is. Yeah, it's this page. It's this page. This empowers you to learn what are the people that are calling you on the phone and writing threatening letters have the authority to do that. If you send them this letter, you will find out fast whether they do or not, because you'll probably never hear from them again. I've used it 9 times. Nobody's reported to me that they've ever heard from them again, which tells me that those collectors were trying to run a con game. If they had legitimate rights, they would have pursued them, but they didn't have legitimate rights. And once they were confronted with something that was sufficient, then they decided that they better go pick on somebody else. Now this brings us to Tim, a real live person that I work with. And this happened 3 years ago. Just happened to run into him at a hockey game. And I don't go to very many hockey games, but anyway, ran into him at a hockey game. And Tim said, with a great deal of urgency in his voice, "You're a lawyer, aren't you?" No, I'm not a lawyer. "Well, you do legal stuff." "Well, yeah, I do legal stuff. What's your problem?" He said, "Well, I've been sued." "Well, how do you know?" "Well, they sued me. I got this summons. Said, you've been sued, and I'm going to have to go to court. They sued me." I said, "Well, maybe. Maybe you've been sued, maybe you haven't." Now, why did I say that? Well, because I suspicioned that it would be the typical BS. And again, what was I relying on? I was relying on the law, because the law says in a disputed matter does not become a case or a proceeding until the law provides for a hearing before a court, and therefore any matter is first judicially determined in a court of some nature. In other words, until you've put the 4 legs under that table, it's not even a case yet. It's not even a case. Now again, I'm not saying this because I love it. I do. But I'm saying it's because of the law. This can go with those others for copying back there. So Tim thinks that he's been sued. And probably 99% of all lawyers and even a lot of judges probably thought he was sued too. And I said, okay, here's what you do. He said, bring me the paperwork. He brought me the paperwork, and I looked at it, and I said, you haven't been sued yet. And he said, but it's a summons. And it says you have been sued. You have 20 days to answer. And I said, yes, but you haven't been sued yet. And here's the reason why. Now, Tim's too young to remember very much about Judge Waltner. But Judge Waltner always began by saying, I've read your complaint. I know you've been sworn. There was nobody in here swearing. Who was injured? Somebody says, I'm injured, then you've been sued. But until that competent witness appeared, it's not a case yet. That's what the law says. And I said, here's what you want to do. Go down to that courthouse. You ask for this case file number. You look in there and you tell me if you see an affidavit. Because if you don't see an affidavit in there, they have yet to name a witness. If there's no witness, there's no injury. If there's no injury, there's no wrong. If there's no wrong, there's no remedy. There's no case. All right. So he went to the courthouse, and lo and behold, when he looked in his file, there was no affidavit. And so he calls me and he says, well, now what do we do? So I say, okay, here's exactly what to do. You compose a letter and it goes like this. It is not now, nor has it ever been my intention to avoid paying any obligation that I lawfully owe. In order that I can make arrangement to pay the obligation which I may owe, please document and verify the obligation. So you make 2 copies. You carry it over to this lawyer's office. You ask him to sign for one of them, and then you ask for the documentation and the verification. Now we know from this morning who can document and verify that. Can that attorney? No, he can't do it. And I'd already coached him of what to say because I was already anticipating what would probably be said. And that attorney said, well, you're here to start your installment payments. We'll get you started. Tim said, no, I'm here for the documentation and the verification of what I owe. Oh, well, yeah, we can document that and we can verify that and we can get you started on some payments. It'll be easy for you to afford them. So, no. I want you to document and verify what I owe. The attorney said, well, now, if you're not going to cooperate, we're just going to have to go ahead and sue you. He said, no, you're not cooperating because I've asked you to document and verify what I owe and you're not doing it. Now then. Is that better? So what we did is we answered their suit, but we also countersued them for fraud and bad faith because they had advanced documents expecting another person to rely on them, which they would surrender money, property, or rights that they had to know were false. How did they have to know that they were false? Because that attorney had an obligation under oath to make an inquiry reasonable under the circumstances to determine whether or not there was an actual obligation. And when he couldn't document, I mean, how hard could that be to document? And when he couldn't document it, that told us that he had committed fraud. But he had committed fraud in the name of the finance company that was now suing him for a deficiency. Now, this Tea Party went on for well over a year. And twice they tried to get a summary judgment against Tim. The lawyers wanted their money, and it wound up there was a team of 3 against Tim, and that's usually how it works out. These guys are so confident in themselves, pleading against a pro se, that they have to show up with a posse. But let's look at the second response to the motion for summary judgment. That's part of your materials. And that's identified as defendant and counterclaimant, John Doe citizens, response to plaintiff and defendant on counterclaims motion for summary judgment. Okay, what's our premise we're going to proceed under? Plaintiff and defendant on counterclaimant's motion for summary judgment is a substantive and procedural nullity. Pretty heavyweight words for somebody representing themselves going into court. Brief in support. Plaintiff and counterclaimant has placed no facts on record. No fact appears on record, whether by deposition, admission, answer to interrogatory, or by affidavit to suggest or to support the averments of plaintiff and defendant on counterclaimant's pleadings. Documents proffered by Dewey Cheatham, it's not the attorney's real name, are unverified, out of date, irrelevant, and inadmissible. The record shows that the defendant and counterclaimant, John Doe Citizen, has testified and testifies again infra, establishing that material facts to which there is substantial controversy are at issue in this case. What's accomplished in this first paragraph? First of all, when you're in a pleading form, you want to know what it takes to win with that form. And when you want to win against a motion for summary judgment, you've got to state that there is a controversy. If there's a controversy, there can't be a summary judgment. And you're stating that there is a controversy, and so the court cannot decide this against you. And you're also saying that the only person that said anything in this tea party is an attorney. And I don't care how high the stack of paperwork gets from an attorney, it never, never rises to a level of fact. If you look at the clear letter of the law as determined by the Supreme Courts, the judge is not even supposed to look at it. It's not supposed to be noticed by the court. Just like Sanders Sauls down there in Florida with those stacks of 20,000 ballots in there, it wasn't noticed by the court because it didn't come through a competent witness. Now we go ahead and state what we feel the controversy is. And then we come down to the argument and authorities, which is the holdings upon which we are basing our empowerment of the court. This is how we empower the court to make a ruling favorable to us. Argument and authorities. Statements of counsel in their briefs or argument are not sufficient for purposes of granting a motion to dismiss or for summary judgment. Trenzi versus Pagliaro. Unsupported contentions of material fact are not sufficient on motion for summary judgment, but rather material facts must be supported by affidavits and other testimony and documents that would be admissible in evidence at trial. And it gives the authority for that. Where there are no depositions, admissions, answers to interrogatories, or affidavits, plaintiff's motion for summary judgment could not be considered under District Court Rule, Oklahoma Statute 12, Chapter 12, Rule 13, providing for judgment where facts are not controverted, inasmuch as there was a complete absence of any requisite basis, misspelled basis there, for proper determination that no substantial controversy existed. And it's coming from where? Our annotated statutes. Any ruling on a motion for summary adjudication must be made on record parties have actually made and not upon one that is theoretically possible. And then I go ahead to list some other authorities there. But it goes right directly, exactly to what we've been talking about. The other side was not entitled to a judgment. They hadn't even established a case yet. Do you think that this is unusual? I estimate that this has happened 50 million times in this country because our legal system is so rotten, attorneys are so lazy, incompetent, and utterly stupid. So, actually happened in the case Well, what happened is they fought on for about another month or so after this. And they called him and they said, "We will leave you alone if you'll leave us alone. Will you please leave us alone? Will you please drop your suit? We'll drop our suit if you'll drop yours." Well, I left it for Tim to decide what to do, because I wouldn't have dropped it, because I want to win. But he had had enough after nearly 2 years of having these people as if they had a gun at his head, that he was really ready to drop it and let it go. But I hope you agree that in the time from when he frantically said, "I've been sued," and when the amount that they were claiming that he was going to have to pay was about $6,000, to actually being able to walk away was not just a victory. It was a tremendous victory in the context of a system. If the pleadings are right, you can win. That's the Tim story. Do you like the Tim story? Now we're going to talk about the Dorothy story. Anybody here ever had a credit card that they kind of had some problems with? Well, I tell you, this credit card business is a racket, isn't it? It's horrible. It's horrible. Well, Dorothy, who is now 70 years of age, had a credit card like most of the rest of us do. And you know, those things are just addictive. And that credit card just got to have a bigger and bigger and bigger outstanding balance. And it eventually got to the point that it was just, she was never going to be able to pay it off. All she could do was just manage to make the monthly payment on that thing, which with its excessive interest rate means that you may never pay that thing off. Dorothy paid conscientiously and probably would have on and on and on, except she had another little problem called the IRS. The IRS worked her over, and by the time the IRS got through working her over, she was ready to quit work. And when she quit work, she did not have the financial means to pay that credit card. The credit card went into default. And then what happens when a credit card goes into default, usually? What do they usually do? They sell it. They sell that obligation. Unless that promissory note is transferable. And even then, only with proper notice. If you sell it, it's dead. It doesn't exist anymore. It's gone. Killed it. Well, it depends on whether there's a transfer clause in it. And if there's a transfer clause, it can be sold if they give you proper notice.
We have a thing on taxes where the so-called county clerk sells it to the sheriff on back taxes. Is it dead?
Well, we'll have to get to that later. We'll try to work that one out in the afternoon session. So anyway, here's Dorothy, defaulted on this credit card, and by the time she defaulted on it, the balance on this thing was $6,000. She sued by a lawyer in the name of the company that had the credit card. Now, she had been, unfortunately at that time, held back by a tether, because she thought she might be protected if she wrote on the outside of that summons, "refused for fraud," and returned it. Anybody heard that one? Okay. Didn't work. It didn't work. That attorney got a summary decision against her for $6,000. Now then, a little bit over a year later, she is compelled to go into court on a hearing on assets. And strangely enough, this $6,000 has managed to inflate to $14,000. How does that happen? I think it's called greed. And so she appeared in court, and that attorney said, "Oh, you better get an attorney. You're in big trouble. You need help. You better get you an attorney. You need an attorney? You better get you an attorney." Well, Dorothy didn't get an attorney. What we did is, because we looked at the record and saw that it was the typical atrocity that had not been done properly, we launched a collateral attack. And this is the last effective pair of pleadings that were filed in that attack. We sued another court, in other words, a collateral attack. Now, in these cases, these are real cases. What I've done is go through them and attempt to remove anything that would actually identify the people in the interest of their privacy. So if you see something there that leads you to conclude that you might be able to discover who that is, please ignore it. But this is the pleading that we filed, because we filed our own petition to vacate this void judgment, and we parried with them for a while. Now we're going to come along and we're going to file our motion for our summary judgment. We're going to get a summary judgment against them. And so we'll read a little bit of that. Mark, you want to read the first page there?
Plaintiff's response to defendant's motion to dismiss plaintiff's motion for summary judgment. Brief in support of plaintiff's response to defendant's motion to dismiss. Defendant's motion to dismiss is a substantive and procedural nullity. Defendant's motion to dismiss is frivolous on its face. If dismissal motion also tenders for consideration materials outside of pleadings, summary judgment procedure must be utilized. Bray versus Thomas Energy Systems Incorporated. Fact is, material for purposes of motion for summary judgment, if proof of that fact would have effect of establishing or refuting one of the essential elements of cause of action, Brown versus Oklahoma State Bank and Trust and Company of Veneta, unsupported contentions of material fact are not sufficient on motion for summary judgment, but rather material facts must be supported by affidavits and other testimony and documents that would be admissible in evidence at trial. Cinco Enterprises Incorporated versus Benso. Statements of counsel in brief or in argument are not sufficient for a motion to dismiss or for summary judgment. Trenzi versus Pagliaro. Where there are no depositions, admissions, answers to interrogatories, or affidavits in support of motion for summary conclusion, the motion cannot be considered. See Oklahoma Statutes Title 12. Pro se litigants cannot be dismissed for failing to state a claim upon which relief can be granted. See Haynes v. Kerner. Although Carl F. Hirsch might presume to advise the United States Supreme Court, this court has knowledge that Dorothy L. Citizen's procedural due process rights require opportunity to present evidence on her claims. Dorothy L. Citizen's petition to vacate a void judgment is procedurally proper, placing substantive fact issues before this court via unrebutted affidavits. See Exhibits A and B.
All right, stop right there. So, starting to sound a little bit familiar. See, a lot of this stuff is just so simple that we cross over it several times before we actually realize what the deal is.
Did this go to appeal, or you did this after they granted the summary judgment? Is that...
It was after the summary judgment had been granted by more than a year.
And you didn't appeal, you just put...
No, Dorothy didn't know to take it to appeal, but I wouldn't have taken it to appeal anyway, because I want to collaterally attack that void judgment. Collaterally attack means that you file your own suit for its removal. See, because
Oh, this is a new suit.
it's a new suit. It's a new suit. Dorothy was clobbered with a suit against her. Now she turns around And she's got to clobber them.
12OS 2011 provides for sanctions against attorneys if they've got a fraud suit. Do you ever bring that into the picture of claims that you're advancing in the collateral attack?
Yeah, did everybody hear the question? The question is that statute in Oklahoma provides for sanction against lawyers that have advanced a false suit. In our pleadings, it was there. We're not done with this yet. In our original pleading, it was there.
Do you bring in the request for damages as a result of the sanctions against the attorneys after there's been a decision rendered in the collateral attack, or do you try to bring that in as part of the entirety of the decision?
You bring it up front. That's what we did.
So when the judgment is rendered, that's included?
Yeah. Yeah. And see, when you can, take as many chances at justice as you can. See, it's just like the question on appeal. And we won this deal, but what if we hadn't won it? And it's just like we did ask for the sanction, and we didn't get the sanctions, but we can still sue in this case.
What if you've already put in the appeal and now wish you hadn't and done this?
Doesn't matter.
Notice of appeal.
Doesn't matter. It doesn't matter. It doesn't matter because actions for void or the queen of the chessboard can do them any time, any place, anywhere, in any court of competent jurisdiction. You can have an appeal pending and still attack it in a collateral attack. That's why it's called collateral.
Can you go after a grand jury the same way?
I don't know.
No.
I don't know. I don't know.
This collateral attack, when you file it, do you file it in the same court as a different case?
The question is, in a collateral attack, is it filed in the same court as a different case? And it depends on the state. Some states will ask you to go back into the same court. Some will ask you to merely go back in the same venue. In Oklahoma, you have to go back in the same venue, but you want to file a separate suit, which gets you before a different judge. You're not asking the judge to review his work. That's why, although it is possible to move for vacation of a judgment, I don't recommend it. The latest question before that was, does the law of voids apply to grand juries? And my answer is, I don't know.
Recording
Deborah,
started.
you want to come up and read a couple of pages? Now, in this, in our motion for summary judgment against them, they responded, and we object to their response. Now, I did this for two reasons. First of all, because their response was not legally sufficient, but also I wanted to give Dorothy, who is 70, was supported by Deborah and a couple of other friends, a little bit of emotional currency when she went into that courtroom to argue against one attorney with two backup. I mean, I guess they think there's strength in numbers or something. I don't know. But there were actually 3 attorneys involved against a 70-year-old woman. And she was terrified. I said, Dorothy, you just got to think about what's at stake here. If you don't get this $14,000 judgment against you removed, you're ruined financially. You're just absolutely ruined. Because you'll never pay it off. They'll take any property you have. And it's just a terrible... So what we did is we objected to their answer, and Deborah's going to read the objection. Okay, this is page 1 of the last 2 pages that are attached to that pleading.
Objection. Plaintiff's objection to defendant's unverified motion to dismiss and defendant's unverified response to plaintiff's motion for summary judgment. Report. Defendant's motion to dismiss can be lawfully considered by this court. Defendant's motion to dismiss pleas matters off record. If dismissal motion also tenders for consideration material outside of pleadings, summary judgment procedure must be utilized. Bray versus Thomas Energy Systems. Fact is, material for purposes of motion for summary judgment is proof of that fact would have effect of establishing or refuting one of the essential elements of cause of action. Brown versus Oklahoma State Bank and Trust.
Peace, peace. What's up? What's up? I'm sorry I took so long to get on. I was actually doing some study. You know, I'm always good at like to go into my old stuff and review it. So this is Richard Cornforth. He's since passed, but I believe he was like one of the best when it comes to fighting debt collectors in court. So the first thing first, peace everybody who's listening. This is Hindsight Radio. Your host Akeem L here on Hindsight Radio. So one thing on my website, if you go to akeeml.com, I got a blog now up there. And on there right now, you will find a sample cease and desist letter template. Click it that you can use to send to the debt collectors. Sample cease and desist letter up there. Or a template that you can use and customize for your use. So you will see more stuff, more and more blogs sitting there with different tips and tricks and stuff like that. Now, he read partially a debt collector letter that he used, and I'm going to read it on the air now for you guys to use in your debt collections. Issues that you might be having. You know, I have his stuff that I bought some years ago to study his moves on how he dealt with debt collectors, and that's how, you know, when you go to court, these guys are not, these lawyers are sitting there giving statements about what happened with no one sitting there with them to testify to make it facts. All right. And that's what you have to attack. We're not going to attack whether you owe money or not. It's not about whether I owe money or not. Who's this person in this courtroom trying to extort me for money? Who are you? All right. Here's a dispute letter to a debt collector, credit card, mortgage, or other loan. And of course, you're going to have your address on there, and you're going to put a certified mail number on the letter, and you're going to address it to whoever the debt collector is, whether it be attorney, agency, whatever. And it says, "Sir or madam, you are in receipt of a notice under the authority of the Fair Debt Collections Practices Act regarding your file." And then you put the file number here. "It is not now, nor has it ever been my intention to avoid paying any obligation that I lawfully owe. In order that I can make arrangements to pay an obligation which I may owe, please document and verify the debt by complying in good faith with this request for validation and notice that I dispute part of or all the alleged debt. Please furnish a copy of the original promissory note, redacting any social security number to prevent identity theft, and state under penalty of perjury that your client named above is the holder in due course of the promissory note and will produce the original from my own and judge's inspection should there be a trial to contest these matters. Please produce the account and general ledger statement showing the full accounting of the alleged obligation that you are now attempting to collect." Now, keep in mind, when a general ledger is everything, including the interest, how everything started from the beginning, all of these charges, which is nearly impossible for them to get because, especially with a credit card statement. They have to show a general letter from the very beginning. They can't just hand you the last statement and say this is the charges. They got to go back to the very beginning. All right, general ledger statement showing the full accounting of the alleged obligation, showing whether there's any fees, interest, anything that you are now attempting to collect. Please identify by name and address all persons, corporations, associations, or any other parties having an interest in legal proceedings regarding the alleged debt. Please verify under penalty of perjury that as a debt collector, you have not purchased evidence of debt and are proceeding with collection activity in the name of an original maker of the note. Please verify under penalty of perjury that you know and understand that certain clauses in a contract of adhesion, such as so-called form selection clause, are unenforceable unless the party to whom the contract is extended could have rejected the clause without impunity. Please verify under penalty of perjury that you know and understand that certain clauses in contract of adhesion, such as so-called forum selection clause, are unenforceable unless the party to whom the contract is rescinded could have rejected the clause without impunity. Please verify under penalty of perjury that you know and understand that credit card contracts are a series of continual offers to contract and as such are non-transferable. Did y'all know that a credit card is a continuing offers to contract and as such are non-transferable? Please provide verification from the stated creditor that you are authorized to act for them. Please verify that you know and understand that contacting me again after receipt of this notice without providing procedurally proper validation of debt constitutes the use of interstate communication and scheme of fraud by advancing in writing, which you know is false, with the intention that others rely on the written communication to their detriment, disputing the debt. Your signature, name. I would put my name up and low with agent for the all caps. That's how I would put the all capped estate right at the end of it. And here's a little note that always dispute your bills. Always dispute your bills. Always. In general. These got stuff when they're trying to get state taxes in here. We're not going to read that. Not going to read that. But that's the sample letter. You're going to have to probably go back and listen to the recording to get it all down. But the main thing was I wanted to talk about a notice of appearance. Notice of appearance. Let me just look it over. So you got a court case. I want you to use a notice of appearance. You got to make it clear who you are coming into that courtroom, yo. Because if you go in there and you say the wrong thing, you're in the trap. All right. Hey, if y'all want to join in and have some questions, there's a number on the top of the screen so you can see it. 717-734-6904, show ID 402-3317. All right, here's the notice of appearance by Akeem Barber, authorized representative for Akeem Barber, which is the all caps. And then right next to, in lowercase letters, italics, Enslegis, Enslegis. To the clerk of court and all parties, please take notice that I, Akeem Barber, up and lower, appear in this matter only as the authorized representative agent for the party identified as Akeem Barber Enslegis. Remember to put that Let them know. I've done this before. I'm actually revisiting something I've already done before. This is styled a little bit differently. This is written differently than in the past. This appearance is made to address matters relating to the proper identification and capacity of the named party. For the record, Akeem Barber is a legal person, entity created by operation of law. I, Akeem Barber, am the spiritual person, natural spiritual person, and not one and the same as the named legal party. I am appearing strictly to ensure the accurate identification and representation of interest in this matter. This note is not to be construed as consent to jurisdiction beyond that which is lawfully established on the record. I reserve all rights, remedies, and defenses available under applicable law. And then you respectfully submit it, sign your name, and you put your name, first and last, authorized representative for the all captains legis, and then you do a certificate of service and you file that. If you're getting sued, that's the first thing you want to make a distinction. I'm telling you, this works. When you put this on the record, all of a sudden the lawyers back off. They stop being so aggressive. Okay? Did y'all get it? If you didn't get it, go back to the recording. All right? Any questions in the chat? Anybody? Anybody? No? Okay. Guess I told you guys, remember the number is 717-724-6904, show ID 4023317. I'm here to take consultations right now. Free. Y'all don't have to pay for it. Jason said no. Now, let me ask y'all a question. Do y'all feel, y'all feel like something's coming down the pipe? Like something's coming, you don't know when, but you know something is coming. Oh, by the way, there's supposed to be some type of object heading towards Earth that's supposed to get here in October. Did y'all know that? Did you know it? Did you know? The articles have been popping up in like off brand media outlets. The main media is not talking about it. And what they are saying is the thing is moving in such a way that it doesn't look like it's like a meteor. It looks like it's a controlled object. Basically suggesting that it might be an alien craft. If y'all don't believe me, look it up. It says October. Around October is when it's coming. Oh, October is my birthday month. Maybe they're coming to take me out to party. Wait a minute, hold on. That's weird. Just thought of something. So we got an object coming towards us. I don't know what that means. Could be something insignificant. Could be something significant. But I feel like something is definitely on the horizon. Coming. I know we're going to have a financial breakdown. I know that. That's coming. We're going to have a whole new reset. Some of us are going to become mega rich, and some of us is going to become mega poor. Which one is it? Which one is it going to be? I am betting on some crypto. They say XRP is going to be the next king, or right next to the king, Bitcoin. That XLM. And what's fun, I'm holding all of those. I've been holding those since before COVID. Not getting rid of it for sure. I'm gonna hold it. I've seen some crazy numbers, like 10,000. I don't think that's gonna happen. Like as fast as they say it's gonna happen. It might happen somewhere down the line, but not as fast as they saying. What y'all think? Are y'all even into crypto? I know Jason's into crypto. What you thinking? Are you still in Brazil, Jason? Huh? Yeah, you still there? It's time for me to come visit. Time for me to take a vacation. After a lot of things going on over here with me, um, I should be settling down by September. I'm almost not like taking a plane is it seems like it's a risky thing to take a plane these days. It's like planes are catching on fire and I feel like right now that the script let me say it like this. Everything we're dealing with is already written. This system has written out its protocol on how they're moving. Nothing is by accident. Nothing is by chance. It's all planned out. Even down to the disasters that they're claiming are disasters. Like right now, it is raining pretty much everywhere. I was reading somebody say they hardly even getting rain, and they getting rain for the straight week. Here, this area is getting the rain all the way until next Thursday. Not this coming Thursday, but the following Thursday. From North Carolina, South Carolina, Virginia, it's going to be raining a week straight. And the temperature drastically dropped. We had 100-degree temperatures, and now it's 60 something, 60 something degrees, you know, from 90-degree weather. See? Yeah. Raining. Like I'm looking at, let me see. Everywhere it's going to be raining for a straight week, pretty much. Let's see. All right. Cancel. South Carolina. All the way, it's going to be rain all the way to Wednesday of next week. That's what they're forecasting. All right. So here, where I am, it's going to rain all the way to Thursday next week. Get a break on Sunday. Thunderstorms next week. Tomorrow it's going to be, yeah. Thunderstorms on Monday and Tuesday of next week. Okay. Let's go. Let's look at Virginia. Only a few days. Virginia, Wednesday, Thursday, Friday of this week. So South Carolina and North Carolina is going to get hit with a lot of rain. Charlotte, all the way to Thursday of next week. So that means, and this is right around the same time that they had that flood in North Carolina last year. Let's see what Asheville, North Carolina looks like. They're the same thing, getting rain all the way to next Thursday. They got one break, and that's Friday. They're gonna supposed to have some sun, but just rain all the way through. We're having some interesting weather. Who thinks we coming into an economic collapse? Who thinks? I think. I think within the next year. That's what's happening. They're working on a reset of things. Be ready. So this is the I don't know if you can order this still. Beating up on debt collectors. This is like my Bible. This guy was like Richard Ron Cornforth was the man. I gotta say it. Because I've helped a lot of people with this book. See, this is the type of like if I'm gonna listen to somebody, I want to see proof and cases, and he has nothing but cases in this book of pretty much every situation you can run into during a lawsuit, dealing with a bank or dealing with lawyers in court. He even had like he even has in here. You know what? That's gonna be one of my next books. I'm gonna put together my court case Bible from the very first cases that I dealt with, and make a Bible of them so you guys can read them and how I dealt with them. This is what he did. You see, he even got in here. Like they'll try to send you requests for admissions and all that kind of nonsense. right, what's the chat saying? Said the new financial system being implemented as we speak. I would agree. And the reason why I agree, I'm in trucking. And the freight rates are crazily low. Crazy low. It's almost like they just moving the essentials around the country. The essentials. And I could tell you, like, we move military stuff sometimes. Well, we move stuff to military bases, airports. So I get to know what's being moved. And the amount of freight that we were moving 2 years ago is really maybe 40% of the freight is being moved today. At the rates is like, for instance, to move a load to New York from, like, say, North Carolina, let's just say going out of South Carolina to New York City, which, like, where we usually come out of Charleston, so Somerville, near in that area, that's roughly around 600 miles, right? We move freight as much as 2,500, on the low end 1,600. That same lane, they're trying to pay like 1,200. I'm not taking a load to New York City for $1,200, not from Charleston, because the gas, and then New York is full of tolls, and it's just, you're gonna spend a couple of $100 just going through the tolls in New York alone, um, not counting the gas. You see, no. If I like to, like, if I'm gonna do a load in New York, depending on what it is, I want to at least get 15 and up, depending on the load, coming from that distance. To get a load going in that direction, paying that much is very scarce now. It's scarce because we have brokers that call us, that'll call me and say, "Hey, we got this load," but I've declined to take them because they don't want to pay. I can't do it. I could stay local making that kind of money. Stay in the area, stay in the vicinity. All right. I guess y'all don't y'all kind of quiet today. Well, if you ain't got nothing to say, I'm getting off. I got some trust to put together. Remember, go to AkeemL.com. The new blog, it's got a sample cease and desist letter there for debt collectors. Also, guess that's what I forgot to mention. The book is out, the ebook on how to set up your ministry. The Elohim Akeem ebook, ministry setup ebook is out. Go to akemel.com and order it. It's got templates in there, detailed instructions on how to set it up, and it also has the best states to set up your church in. Okay? All right. That reminds me. See what this says. All right. Also, go to my Telegram channel, and I will be playing Reverend Ike tonight. Back to back. I got some new recordings thanks to my good friend Steve. He gave me some new Reverend Ike recordings that I've added to the playlist. So there you have it. Since y'all so quiet, I'm gonna get quiet. Practice my guitar. Go work on some trust, and go to bed. I don't have much. I gave y'all. Look, what did I give y'all tonight? I gave you Richard Cornforth's debt collector letter, and I gave you a notice of appearance. So if you did get on late, go back and listen to the beginning. I'll give somebody one chance, and I'm out of here. 717-734-6904. There is the show ID if you want to join in and have a conversation. That's the only way I'm staying on. I'm going to give y'all 2 minutes, and then I'm out. While y'all do that, think about that. Do a little practice. Do some practicing. This is a song. It's an old song that I've been practicing for the last week, preparing for my lessons tomorrow. All right. Let's see what the chat's saying. All right. I'm out. What is the website again? It's akeeml.com. There it is. I'm revamping it. Playing my guitar is like a stress reliever for me. And learning an instrument, especially an instrument like a guitar that's so there's so many things you got to do and finger positions and um See, to get that finger right to get those notes to come out. Mhm. All right, I want to buy the ebook. All right, go get it, man. I appreciate your support. You'll like it. When I come out, I'm working on right now the trust ebook. How to properly trust, set up your trust, how to I'm gonna include in there how to get your EINs without using the social, all of those things. So get that ebook. You'll like it. It will definitely help you set up your ministry properly. And when I add the trust, like in the book, I touch on the trust and the structures, even show a diagram of how they are supposed to be connect to each other. So when I do the actual trust diagram and ebook, that's going to be um that's going to be even better than this book. Yeah, appreciate it. Yeah, can't wait. Go get it. Um, I'll be putting up the pre-sale of the trust book. That's going to take me a little bit longer to come out with the trust ebook because there's a lot of details, moving parts with the trust, a lot of scenarios. The good thing about it, I got a lot of the content already put together. I'm just buying time to see if you guys want to call in or something. I'm trying to get this call-in vibe going. I'm gonna get it. I'm gonna get it. Oh, let me activate the Telegram channel because I'm gonna play some Reverend Ike when I get off. Play some. We got 12 likes. Like it. To me, that's a lot. Can y'all help me get to 10,000? Like I've been sitting around 9,996. I just need to get 10,000 followers. That's the blessing and the curse of being a person who gives truth. You will never be loved by the masses. If you're a truth teller, you will never be loved by the masses. Just accept that plight. Just accept it. Your plight is never 9,994. Been sitting there for days now. I just need 6 more to go to thing. 6 more. To get that $10,000 plaque. 10,000 follower plaque, whatever it is. think it's just a little certificate they send you. All right. I want to announce tomorrow's show. Tomorrow's show is Unbalanced Soul with me and Raquel. Support the show. We've been having some good discussions over the last. It's been a month since we started the show. 1 month. All right, let me stop playing around. I'm out. I will see you guys tomorrow evening. Peace. Let me see. I'm going to leave y'all with a little Richard Cornforth. The very first video.
Movements, Patriot sympathizers. I think it's safe to say that some of the things are truth than an attractive lie. So at any time during a program, if I say anything that's contrary to what you've been told, what you've been led to believe, and it kind of makes you wince a little bit, bear with me, let me make my case. Because I think by the end of the presentation, I think I may share something with you that you can actually take away from here and actually benefit from, hopefully. If I do my job, that's what I'm here to do. Are we ready? Good morning.
Good morning.
How is everybody? This is my inaugural seminar. I'm here to share some secrets about the legal industry. I have a couple of helpers, Deborah Lee and Mark Mays, that are fellow members of an Oklahoma City due process organization known as TACUS. My name is Richard Cornforth. I'm the person that was billed as being the one to put this on. I don't have anybody to introduce me, so I guess I'm introducing myself, but I'm not going to do much in the way of introducing. I will tell you that I'm not an attorney. I have absolutely no formal legal training at all. I'm not a legal expert. I'm not a legal advisor, not a legal counselor. And in fact, when it comes to knowing things about law, if I were in a contest, I probably wouldn't get past the first round. There's probably people in this room that know more about law generally and certain subjects than I do. But I am not intending to make a long-winded speech to try to impress you with everything that I know about law. What I'm here to do is tell you a few secrets that I believe will enable you to win. If I'm you sitting out there and I'm listening to me, what I would be here to find out is tell me how to win. I want to know, how do I win? We've all been around this movement for 5, 10, 15 years. And we've all heard speeches, we've all been to seminars, we've all had this massive amount of information that we've been asked to absorb, assimilate. But it seems that the part of the formula that's missing is somebody needs to tell us how we use information to win. Are we somewhat in agreement with that? Okay, all right. So if I can tell you something that will empower you to win, I think we're all winners. And that's what I'm intending to do, and I'm going to try to make it a little bit of fun, too, because this struggle that we're all in has been so hateful and mean-spirited and downright dishonest that the only things that I can think of to compare our legal industry to that have happened in this century are things like the Gestapo, the Mafia. It's hateful. It's evil. But if you didn't have a little bit of comic relief, I think it would destroy you emotionally. So we're going to try to have a little fun with this today too. So I'm not any kind of a big shot legal advisor expert. In fact, kind of think of me this way. I'm kind of like your old kindly Uncle Luke, and Luke is my middle name. And remember that because it'll be important later. But it's kind of like I've come up behind you and I'm watching you playing checkers, and I notice a triple jump that you've overlooked. And I'm there whispering, you know, take that triple jump, look, right there. And one of the things about the law business, the legal industry, is some of the most important things about law are actually so simple that they're easy to overlook. They're just absolutely so darn simple that in an effort to try to understand them, we make them way too complicated. And in an effort to try to lead this movement towards some new day when we can all achieve what we want to through the legal system, there are some false prophets. There's a lot of misinformation. And so one of the things that I hope to accomplish today is free you of your tether. You know what your goal is, and you've been struggling for years to reach that goal. But I'm here to tell you, friends, you probably didn't reach that goal because you're on the end of a tether and didn't realize it. And I want to cut that tether. I want to set you free of that tether by giving you a different approach and some different information. And there are only about 4 very simple truths. And if you know and understand these truths, you will be empowered to win. Nobody can guarantee a win. Our legal system for some time to come is still going to be a crapshoot. But you can win, and we're going to actually look at 4 cases out of a goodly number of cases that I've worked in. These are real cases. And we're going to fit what I call the truths about the legal industry. We're going to see how those are actually threaded into these pleadings and how this empowers us to win. If you walk into a courtroom and you see a flag, and that flag has gold fringe around it, do you think that that means that you're in a military court or a court of admiralty or maritime jurisdiction? How many have heard that? How many believe it? How come? How come? Why? Okay. Here is the first truth which I have to share with you. That court does not get its jurisdiction from that flag. It doesn't even matter if there even is a flag there. That flag does not confer jurisdiction on that court. Here's the first great secret. Where does the court get its jurisdiction? Well, first of all, there are actually 2 levels of courts. We have a 2-tiered court system. There are the Supreme Courts and their tribunals. There are courts of inferior jurisdiction. And I imagine most of the minds in this room are clicking and say, yeah, I've been in some of those inferior courts, and they sure are inferior. Now, when we're talking about Supreme Courts, like the United States Supreme Court and the Oklahoma Supreme Court, where do they get their jurisdiction? They get their jurisdiction because of who they are. They are constitutional courts. But what about these courts of inferior jurisdiction? Where do they get their authority? Where? Kind of, because they're legislative courts. Congress created the federal court system. It's not in the Constitution. Congress created it to settle cases and controversy. But when a judge of an inferior court puts on a black room and walks into that room and the bailiff says, "All rise," is that person a judge at that moment? No. The reason they're not a judge at that moment is because they have not established jurisdiction. Because they don't have jurisdiction like these people do. Now we know in all of these struggles, we're in this level down here when we start our fight, or when we're pulled into that fight. Where do courts of inferior jurisdiction get their power to act? No. No. Yeah, you got it right. The courts of inferior jurisdiction are empowered to act by pleadings sufficient to invoke their judicial authority, which means that the people, not the attorneys, the people that walk into that court empower that person in a black robe to be a judge. That person is not a judge until actually 4 things happen. There's 2 very important things. How many remember Judge Wapner? Man, that guy was great. He was great. It's too bad that we can't clone him and send him up and let him be the Supreme Court. If you remember those old programs, Judge Wapner always began every court session with the same pronouncement. Do you remember what it was? "I've read your complaint. I know you've been sworn." He never conducted a session until he said, "I've read your complaint. I know you've been sworn." Until he did that, he was not a judge. Because a judge is somebody that has judicial power. He did not have judicial power until he did that. Now, jurisdiction has 4 corners on it. It's a 4-legged table. It's not a 3-legged table or a 2-legged table or a 1-legged table. It's a 4-legged table. And if you take away one of those legs, it's not a court anymore. It won't stand. It'll fall down. And we are going to understand how we put 4 legs under that table. And we're going to understand what we can do if our money or property was taken in a 3-legged deal. We're going to learn how to do that. It's possible. Now then, so that's the first secret. Now, y'all seem to be somewhat embraced of that, so maybe it's not a great shocking secret to you. But the reason I mention it is determine what your winning point is and focus on it and plead your winning point. Don't go into a courtroom and tell the judge, "Judge, I'm not going to step in front of this little bar because you'll get jurisdiction." Or, "I want you to move that flag because that's wrong jurisdiction." That's tether. That's holding you back. You don't win with that stuff. At least I don't know anybody that does. You win when you know how to invoke the court's jurisdiction, when you empower that judge to make the decision that you want that judge to make. Now then, if we get our marvelous Constitution, and our Constitution is marvelous. By that I mean our United States Constitution is marvelous. And we go to a certain article in that Constitution and we read it, like a Second Amendment or a First Amendment or whatever we're thinking we're pursuing, Fifth Amendment, whatever. We read that Constitution, are we informed of what the law of the land is? No. No. That's the second great secret, is the Constitution, state constitutions, statutes, laws, rules, what meaning do they have as you read them in their black and white print?
Instructions to government.
True, but we won't go there. As far as what they mean to us, they don't really mean anything except a hint, a suggestion of what the law is. Because we have a common law system. The American common law system is arguably based on the English common law system, which I think is actually based on Viking law, but that's another story for another day. But we have a common law system. Now, I know that there's probably some controversy about what's meant by common law, but a common law system means that you can't read the Constitution, the statute, rule, or anything else and know what it means because there is a cluster of organizations that rules and determines and tells you what it means. And that's back over here. That's these Supreme Court people. The Supreme Court tells you what that means. You think the Second Amendment gives you the right to keep and bear arms? Maybe. But who do you have to ask what the Second Amendment means? The Supreme Court. They're the guys that tell you this is what this law means. Now, you can waste a lot of time, a lot of effort, and a lot of energy and get false hopes and get crushed if you read some statutes or some rules or some constitutional articles and start thinking that that establishes a basis for whatever you want to accomplish. The Constitution, the statutes, and the rules, as far as we're concerned, are largely silent because they don't tell us what the law is. To find out what the law is, we have to find out what the Supreme Courts have said that that particular law means. Now, that's the second great secret. But it's really pretty simple stuff because we have a means of finding out what the law is. It's written down. We can go read it. We can rely on it. We can use it. And if we're in a court of competent jurisdiction, it's fair, open, and honest, which is not a given, is it? But we can win, can't we? Where do we find the common law? Where do we find this common law that we can rely on? There's only one type of book that has this common law. It's the federal and state annotated statutes. Now, if you can go on the internet and find the federal and state annotated statutes, are a better web browser than I am. Because, again, that's a secret. They don't want you to know that. If you can read the annotated statutes, now you know what the law is. Now you're empowered to act. You can go into a law library, and I often do, over at the state capitol. There must be 100,000 books in there. I don't know, maybe several 100,000. But when I go in there, I go right back to the state annotated statutes. Because I know that all of those other books are probably philosophy of law. Those annotated statutes are going to tell me what the law is. By reading them, I'm going to know what the law is. And here's another thing that's really kind of shocking, or maybe it's shocking, it was shocking to me when I discovered it, is I used to have the belief that if I was going to know enough about law to actually argue effectively, man, I was going to have to spend thousands of hours in a law library. And I've spent probably several thousand hours in a law library. But you're way overshooting your mark because it's not complicated. It's actually very simple. Because the annotated are not going to publish law cases. They're going to refer to them as the decision, but they're going to publish the holding. They're going to tell you the essence of that decision. And that essence of that decision out of that case is that one paragraph, that one sentence, or maybe just that one phrase that you need to win, and that's all you need if you know how to use it. At this time, I'm going to ask my associate, Mark Mays, to read a case. He's going to read a case in its entirety. This is going to be the only case that we're going to read today, because to me, there's a lot of things I'd rather do than read a case. But we're going to read one to illustrate this point. Mark Mays is going to read a case called Trenzi versus Pagliaro. Trenzi versus Pagliaro is one of the most important cases that has ever been decided by the United States Supreme Court.